Rachel didn't know that the man sitting directly across from her had spent 14 months preparing for this exact moment. She didn't know that buried inside a supplemental evidence file submitted to the court 3 days earlier was a document her attorney had never traced to its origin. And she certainly didn't know that in approximately 4 minutes, every assumption she had built her case upon would be quietly dismantled by a single page dated 1998. She laughed. Not nervously, not quietly. She laughed the way people laugh when they believe the outcome has already been decided, open, unhurried, with the particular ease of someone performing for an audience. Her attorney, Gordon Ashby, sat beside her with the composed confidence of a man who had already counted his fee. Rachel straightened in her chair. She smoothed the lapel of her navy blazer with one practiced motion. "The house is mine," she said, just loud enough for the room to register it. "You're homeless now." I did not look at her. I adjusted my tie, not because it needed adjusting, but because my hands needed somewhere to be that wasn't a fist. I placed them flat on the table afterward, palms down. Still, I had learned years ago that clenched hands invite interpretation. Judge Harold Stanton did not respond to Rachel's remark. He did not acknowledge it at all. He sat at the bench with the unhurried patience of a man who had spent 3 decades in rooms exactly like this one, and he turned pages the way auditors do, one at a time, without rushing, looking for what others had missed. He adjusted his glasses. He stopped turning. "Counsel," he said, his voice flat and even, directed at no one in particular. "I have the supplemental evidence submission before me." He opened the folder. He found document 29. The room went quiet in the specific way that rooms only go quiet when something is about to change, and not everyone present understands it yet. The clock on the wall of courtroom 7 read 10:04 a.m., not 10:10, not sometime mid-morning. 10:04 a.m. on a Thursday in March of 2024, with the kind of cold that doesn't come from weather. It comes from fluorescent lighting and air conditioning set to a temperature that no one inside the room actually requested. The ceiling vents hummed in a low, continuous tone, the kind you stop noticing after the first few minutes, but that your body registers the entire time. The room smelled like old paper, ink, and the faint chemical residue of industrial disinfectant, the same smell every courthouse carries, as if the buildings themselves are trying to neutralize something. Courtroom 7 was smaller than people imagine courtrooms to be. There was no gallery packed with spectators. There were no dramatic echoes. There were worn wooden benches along the back wall occupied by 3 people, a paralegal for Gordon Ashby, a court-appointed recorder, and one other individual whose presence would matter later. The ceilings were lower than they appeared in films. The light was worse. Rachel sat at the petitioner's table to my left. She wore a navy blazer over a white blouse, the collar folded with deliberate precision. Her posture was the kind that takes practice. Back straight, shoulders rolled slightly back, chin positioned at an angle that communicated composure without appearing to try. She had worn the pearl earrings she kept for occasions she considered important. Her hands rested on the table in front of her, both of them wrapped loosely around a single pen, which she turned slowly between her fingers. Not from nervousness. Rachel did not do nervous in public. She turned it the way someone turns a prop, because having something in your hands makes you look occupied, purposeful, unbothered. Her attorney, Gordon Ashby, sat beside her with a leather portfolio open in front of him, 2 neat stacks of documents aligned at its edges. He was 61 years old, experienced in exactly the kind of high-asset divorce proceedings that Rachel believed this to be, and he had the particular calm of a man who considered the work already finished. He had reviewed the evidence. He had prepared his arguments. He had not, however, reviewed document 29. I sat at the respondent's table to the right of the room's center axis. My hands were flat on the table, palms down, fingers open, not a performance, a discipline. I had spent 22 years in rooms where the wrong posture could signal weakness before a single word was spoken, and I had learned early that still hands don't invite interpretation. Closed hands do, crossed arms do. A jaw held tight does. Still, open hands suggest a man with nothing to hide, and I had nothing to hide. Claire Donovan sat to my immediate left. She had a single folder open in front of her, and she was not looking at it. She was watching the judge. Judge Harold Stanton settled into the rhythm of the room the way experienced judges do, without announcing it, without requiring acknowledgement. He had been on the bench for 31 years. He had presided over enough asset disputes to recognize the architecture of one before the first argument was made. He read carefully. He did not perform reading. There is a difference. The clock advanced to 10:06 a.m. Rachel turned her pen once more between her fingers. I kept my hands flat and I waited. My name is Daniel Mercer. I am 51 years old. I was married to Rachel for 19 years. I work in asset and patrimony auditing, not the kind that earns headlines or draws attention at dinner parties. I review financial structures. I trace ownership chains. I verify that documents say what people claim they say, and that the records behind those documents are consistent with what was filed, registered, and signed. It is quiet work, methodical work, the kind of work that most people find too detailed to care about, which is precisely what makes it useful. Rachel had a name for what I did. She called it paper shuffling. She said it the way someone says it when they want the description to diminish, not to inform. Over the years, I heard it at dinner tables, at social gatherings, in hallways during other people's conversations. Daniel does compliance work, paper shuffling, really. She smiled when she said it. I never corrected her. I liked systems. I liked order. I liked the particular clarity that comes from tracing something back to its origin, from following a chain of records until you arrive at the document that started everything else. Most people find that tedious. I find it reliable. There is a difference between what people say happened and what the paperwork confirms. I had built a career on that difference. My father, Thomas Mercer, understood that difference too. In 1998, 6 years before Rachel and I married, Thomas established an irrevocable banking trust, designating me as the primary beneficiary of the property that would become the Mercer mansion. He did not do it carelessly. He did not do it informally. He did it the way men of his generation did important things, quietly, correctly, and with documentation that did not leave room for reinterpretation. Rachel never believed I understood what I had. That was her first mistake, and ultimately her only one that mattered. The first time Rachel called the mansion ours, I did not correct her. It was the spring of 2005, roughly a year into our marriage, and we were standing on the front steps after a Sunday afternoon drive through the neighborhood. The light was coming through the trees at the angle it only reaches in April, low, amber, cutting across the lawn in long horizontal lines. She stood beside me with her hand on my arm and looked at the house the way someone looks at something they intend to keep. Ours, she said. I remember thinking it was a natural thing to say. We were married. We lived there. The word made sense in the way that simple words often make sense before you understand what someone means by them. I did not understand yet what Rachel meant by most things. We had met in 2002 at a financial services conference in downtown Philadelphia. She worked in acquisitions consulting at the time, a role that suited her in ways I would only fully appreciate later. She was precise in the way that people are precise when precision serves them. She asked good questions and listened to the answers with the kind of focused attention that at the time I mistook for genuine interest. We married in the fall of 2004. She moved into the house my father had maintained since 1991, and for the first years of our marriage, life was unremarkable in the way that good lives sometimes are. Structured, steady, without the kinds of disruptions that force you to examine the architecture beneath the surface. My father, Thomas, was a deliberate man. He did not speak often about money, but when he did, he spoke about it with the gravity of someone who had watched others lose what they had built through carelessness or misplaced trust. He had established the irrevocable trust in 1998 on the advice of his estate attorney, a trust that designated me as the sole primary beneficiary of the Mercer property, registered through a notary office in a neighboring state where his attorney practiced. He never explained it to me in full detail while he was alive. He only said once that the structure was designed to be clean and that I should never let anyone simplify it. I did not fully understand what he meant until after he was gone. Thomas Mercer died in February of 2013. He was 78 years old. The winter had been harsh, and the illness had moved faster than any of us had anticipated. I spent the final 3 weeks before his passing driving between our house and the care facility twice a day, and when it ended, the grief settled into me the way grief does when it has been deferred too long, all at once, in the quiet moments, without warning. Rachel was present throughout. I will say that clearly because it is true. She attended the service. She managed the phone calls during the first week. She handled the coordination with the funeral home with efficiency and composure, and in those weeks, I was grateful for her steadiness, because I had very little of my own. It was during that period, in the 6 weeks immediately following my father's death, that Rachel first raised the question of the estate documents. She raised it gently. That was always her method. Rachel did not demand things directly. She suggested them, framed them, surrounded them with reasonable context until the suggestion felt like the most sensible option available. The estate attorney called again, she said one evening in March of 2013. We were in the kitchen. I was sitting at the table with a cup of coffee I hadn't touched, and she was standing near the counter with a folder open in her hands. He says there are some administrative documents related to the property that need to be updated following your father's passing. Standard procedure after a transfer of estate responsibility. He says it's easier to handle now rather than waiting. I looked at the folder. Is it urgent? He says sooner is better. Just administrative. Updating records. Consolidating the filing structure. Nothing complicated. I signed 3 documents that evening. I did not read them with the attention I would have given to documents in a professional context, because Rachel had positioned them as routine, and because I was operating in the fog of someone who had recently lost his father and trusted the person standing in his kitchen presenting him with paperwork. I trusted her. That is the simplest and most complete explanation. I trusted her because 19 years of marriage at that point had not yet given me a specific reason not to. The documents were not administrative updates. I would learn this much later, when Claire Donovan traced them during our case preparation. What Rachel had arranged, through a private attorney she had consulted independently, not through my father's estate lawyer, was a set of filings designed to establish joint nominal ownership of the property, layering her name into the title record as co-holder. It was not crude. It was not obvious. It was the kind of restructuring that appears unremarkable in isolation, but creates a legal foothold when combined with other evidence of financial contribution. Over the 3 years that followed, from 2013 through 2016, Rachel constructed that evidence methodically. She began making traceable financial contributions toward the property's maintenance and improvements. New roofing in the fall of 2013. Interior renovation of the East Wing in the spring of 2014. Landscaping and exterior restoration in 2015. Each project paid for in part through accounts under her name, with receipts retained and organized in a manner that suggested careful record-keeping. At the time, I interpreted this as conscientiousness. Rachel had always been organized. I did not read it as construction. What she was building was a financial narrative, a documented record designed to support a future claim that she had invested substantially in the property during the marriage and that her contribution entitled her to an equitable share of its value. In a standard marital asset dispute, that narrative would have been compelling. It was specific, documented, and consistent across 3 years of records. There was one problem with it. The trust my father had established in 1998 was irrevocable. That word has a precise legal meaning. It cannot be altered, amended, or overridden by subsequent administrative filings. The primary beneficiary designation entered into that trust in 1998 could not be displaced by documents signed in a kitchen in March of 2013, regardless of what those documents said or who had witnessed them. The trust's legal authority was absolute and predated the marriage entirely. Rachel's attorneys would have needed to find it, trace it to its registered origin, and understand its structure in order to account for it in their case. They never found it. The trust had been registered through a notary office in a neighboring state, not in the city where we lived, not in the county where the property was located, not in any of the jurisdictions where Rachel's attorney, Gordon Ashby, would have naturally searched when building her claim. It was not hidden deliberately. My father had simply used the attorney he trusted, and that attorney practiced out of state. The document existed in a public record. It was findable, but you had to know where to look, and you had to follow the chain far enough back to reach 1998. Rachel and Gordon had traced the records back to 2013, to the documents she had arranged, the renovation receipts, the maintenance records. They had built a case from those materials and considered it complete. They had stopped 11 years short of the origin. I did not confront Rachel about any of this during the marriage. I did not confront her when I first began to suspect, sometime in 2019, that her financial engagement with the property had been more strategic than affectionate. I am not a man who confronts. I am a man who documents. I watched. I noted. I retained records that she did not know I was retaining, in the same quiet and systematic way I had spent 22 years doing professionally. Rachel had always believed that silence meant emptiness. She mistook restraint for absence. She mistook patience for ignorance. And somewhere in the years between 2013 and the morning she handed me divorce papers, she made the single assumption that would cost her everything. She assumed that the man she had described, for 19 years, as a paper shuffler, had never bothered to read his father's papers. The petition arrived on a Tuesday in October of 2023 at 2:41 p.m. I know the time because I had just returned from a site review across town and was still in the car when the courier van pulled up behind me in the driveway. The driver confirmed my name, handed me a thick envelope sealed with a law firm's return address I did not immediately recognize, and left without waiting for a response. I sat in the driver's seat with the envelope in my hands for a moment before I opened it. The document inside was 41 pages long. I read it the way I read every formal document, from the first line in order without skipping ahead. Rachel had filed for dissolution of the marriage and was requesting, as part of the settlement, sole proprietorship of the Mercer property and all associated assets, on the grounds of documented financial contribution throughout the course of the marriage. The language was precise. It cited the renovation records from 2013 through 2016. It cited the joint nominal filing she had arranged through her private attorney in March of 2013. It presented those materials as the foundation of a coherent and well-documented ownership claim. When I reached the line that read, "Sole proprietorship claim, primary residence and associated real property holdings," I stopped. My fingers went numb. Not from cold. The car was warm. It was the particular physical response that comes when something abstract becomes suddenly, irreversibly concrete. I had suspected for years that the marriage had been moving toward an exit. I had not, until that moment, seen the exit fully drawn. I sat in the driveway for 6 minutes. I did not go inside. I did not call anyone. I held the petition in both hands and read the sole proprietorship line a second time and then a third. The way you reread something not because you failed to understand it, but because you want to be certain you understood it correctly before you decide what to do next. Then I set the document on the passenger seat, face down. I went inside, put my bag down, and changed out of my work clothes with the same routine I followed every evening. I made coffee. I sat at the kitchen table for a while and looked at the window without looking through it. At 9:38 p.m. I opened my laptop. I did not begin with Rachel's documents. I did not begin with the 2013 filings or the renovation records or the joint nominal title she had constructed. I began where my father had always told me to begin, at the origin. I opened the folder I had maintained since Thomas's death, the one that contained his estate correspondence, his attorney's contact records, and the original documentation he had left in my care. I found the reference to the trust within the first 20 minutes. Not the trust itself, the reference to it. A letter from my father's estate attorney, dated November of 1998, confirming the completion of an irrevocable trust filing for the Mercer property, with a notation that the original registration documents were held on file at the notary office where the attorney practiced. I read the letter twice. Then I wrote down the attorney's name, the name of the notary office, and the state in which both were located. I circled the word irrevocable with a pen, the way I used to circle discrepancies in financial audits, not dramatically, just precisely, so that the notation was clear and would not be overlooked later. I closed the laptop at 11:14 p.m. Something inside me had shifted. Not toward anger, not toward urgency, but toward the particular stillness that arrives when you realize you are not, in fact, starting from nothing. I had been handed a 41-page claim built on a foundation that stopped in 2013. My father had left me a document from 1998. Rachel had counted on the paper shuffler, never reading his father's papers. It was the only calculation she had made that I could not forgive. Not because it was cruel, though it was, but because it was wrong. And in my experience, wrong calculations have a specific and reliable consequence. They produce accurate corrections. I contacted Claire Donovan the morning after the petition arrived. I had been referred to her 8 months earlier by a colleague who described her as someone who read documents the way engineers read blueprints, not for the surface meaning, but for what the structure revealed about the decisions made before the first line was written. She had spent 11 years in family and estate law. She did not specialize in high-profile cases. She specialized in accurate ones. We met at her office on a Wednesday morning. I brought the petition, the estate letter from 1998, and a personal file I had maintained since Thomas's death, organized chronologically, with notes on each document's origin, the date I received it, and any related correspondence. Claire sat across from me and read through the file without speaking for 22 minutes. When she looked up, her expression had not changed significantly, but something in her attention had sharpened. "The trust reference in this letter," she said, setting the 1998 estate correspondence on the table between us. "You've never retrieved the original registration documents." "I knew they existed. I didn't know I would need them." She nodded once, the way people nod when a fact confirms something they suspected rather than surprises them. "We need them. If the trust is irrevocable, and the original designation is what I think it is, her entire claim rests on documents that cannot legally override it." She paused. "But we have to find the original. The reference isn't enough. I know the notary office. I have the attorney's name and the state. Then that's where we start." Day one began that afternoon. Claire contacted the notary office directly, a private firm that had been operating under the same name since the mid-1980s and retained physical records for all filings. The initial inquiry confirmed that records from 1998 were archived, but not digitized. Retrieving them would require a formal records request with verified identification and documentation of beneficiary status. Claire filed the request the same afternoon and marked it urgent. Day two, we waited. I spent the morning reviewing Rachel's petition in full detail, not emotionally but analytically, the way I would review a financial report with known irregularities. Her claim rested on 4 pillars: the joint nominal title filing from March of 2013, the renovation and maintenance expenditures from 2013 through 2016, a property appraisal commissioned in her name in 2018, and a sworn statement from her private attorney confirming the 2013 filing process. Each pillar was documented. Each document was real. The case she had constructed was not fabricated. It was selectively built on a foundation that excluded 1998 entirely. That afternoon, Claire called with a preliminary confirmation from the notary office. The records existed. The 1998 filing was on file. They were processing the retrieval request. Day 3 was the first day I came close to losing my composure. It was not the legal situation that produced it. It was an evening at home, sitting alone in the living room with the lights low, scrolling through photographs on my phone that I had no specific reason to be looking at, photographs from earlier years, from vacations and ordinary weekends, and one specific afternoon in the spring of 2007, when Rachel and I had spent the day repainting the back porch for no reason other than that the weather was good and we had the time. I looked at that photograph for longer than I should have. I thought about what that afternoon had felt like, and about the distance between what it felt like and what I now understood it to have been adjacent to. I stood up. I walked to the hallway. I stood there for a moment with my hand on the wall. Then I walked back to the living room, sat down and closed the photographs. Emotion gives them room to rewrite the story. Claire had said it to me during our first meeting, offhandedly, when I had started to describe the 2013 document signing in terms that were more personal than professional. She had said it without particular emphasis, as if it were a fact she had learned through repetition, rather than one she was presenting for effect. I had not forgotten it. I returned to it on day 3, standing in my hallway, and it did what it was designed to do. I went to the kitchen table and opened my laptop instead. Day 4, the records arrived. Claire called at 9:44 a.m. The notary office had located the original filing and transmitted a certified copy via secure document service. She had it in hand. She read me the relevant designation language directly from the document, her voice steady and precise. Irrevocable trust designation. Primary beneficiary. Daniel Mercer, sole and exclusive. Property. The Mercer residence and all associated real property holdings. This designation is irrevocable and may not be amended, transferred, or superseded by subsequent filing without the express written dissolution of this trust by the establishing party. I did not speak for a moment. The establishing party, I said. Thomas Mercer, deceased February 2013. So it cannot be dissolved. It cannot be dissolved, Claire confirmed. He's the only one who could have revoked it, and he is no longer living. The trust is permanent by operation of law. Whatever Rachel filed in 2013 has no legal authority to override a pre-existing irrevocable designation. Her attorney built his entire case on documents that are legally subordinate to this one. She paused. Daniel, this is document 29 in the supplemental filing index. I want you to remember that number. Day 5, Claire began preparing the supplemental evidence submission. The rules of the court required that evidence intended for use at the final hearing be submitted through proper procedural channels, filed formally, with notification to opposing counsel and subject to the judge's acceptance. Claire drafted the submission request that evening, attaching certified copies of the original 1998 trust documents, the primary beneficiary designation, the irrevocability clause, and the notary authentication from the out-of-state office. She filed it the following morning and received confirmation of judicial acceptance by early afternoon. Gordon Ashby was notified of the supplemental filing the same day. I asked Claire what she expected his response to be. He'll review the notification, see that it's a trust document from 1998, and assume it's a standard estate reference that we're introducing to establish historical ownership context. She set down her pen. He won't trace it back. He built his case starting from 2013, because that's where the relevant activity appeared to begin. Going back further will seem unnecessary to him, because in most cases it would be. He will not expect that the origin document is structured to override everything he filed. You're certain he won't look further? I'm certain that he is 61 years old, has been practicing family law for 30 years, and has never lost a high-asset case where the petitioner had 3 years of documented financial contribution and a joint nominal title on record. She looked at me evenly. He's not going to look further. He doesn't believe he needs to. She was right. Gordon filed no counter-response to the supplemental submission. He requested no clarification from the court regarding document 29. He did not contact Claire's office with questions. In the 6 days between the supplemental filing and the final hearing date, there was no communication from Rachel's legal team that suggested they had traced the 1998 trust to its registered origin or understood its irrevocability clause. They had received the document and set it aside. Day 6 was the last day before everything changed, though not because of anything that happened in our preparation. It was the day Rachel made her error. Claire forwarded me a link that evening with a single line of text. She gave an interview. The article had been published on a regional real estate and lifestyle platform. The interview was titled something about reclaiming space and featured Rachel discussing, in general terms, her plans for the property following the finalization of the divorce proceedings. She described the mansion as a long-term personal project. She mentioned potential renovation plans. She spoke about the neighborhood with the quiet authority of someone who has already been told they have won and is now performing the victory in advance of its official confirmation. She was photographed on the front steps of the house, arms folded, composed, looking directly into the camera. I read the article once. I did not feel what Rachel likely imagined I would feel upon reading it. Not anger, not humiliation, not the particular defeat of seeing someone stand on a thing they intend to take from you. What I felt was closer to recognition. The interview was the behavior of someone who had stopped being careful because she believed the outcome was already secured. It was the behavior of someone who had not read document 29 closely enough. "People only rush when they're afraid something will show up late," Claire had told me during our first meeting, quoting something she had learned from an old mentor of hers. The inverse, I thought, was equally true. People only perform victory in advance when they are certain nothing is coming that they haven't already accounted for. Rachel was certain, and she was wrong. I closed the article. I set my phone face down on the table. The hearing was in 4 days, and everything that needed to be prepared had been prepared. The trust existed. The designation was irrevocable. Document 29 was part of the official court record. All that remained was the room. Gordon Ashby rose first. He had the posture of a man performing a closing argument. He had rehearsed enough times to deliver without thinking about it, measured, unhurried, calibrated to project the quiet authority of someone presenting facts rather than making a case. He walked the court through Rachel's submission systematically. The joint nominal title filing from March of 2013, the renovation expenditures documented across 3 years, the property appraisal, the sworn statement from her private attorney. Each document placed before the bench in sequence, each one real, each one precisely what it claimed to be. Rachel sat with her hands folded on the table. She did not fidget. She watched Gordon present the case she had spent years constructing with the particular stillness of someone watching a performance they have already seen and know ends well. When Gordon finished, he returned to his seat and settled the portfolio closed in front of him with the quiet finality of a man who considers the work complete. Judge Harold Stanton did not respond immediately. He reviewed the documents Gordon had submitted, not quickly, not performatively, but with the methodical attention of someone who reads for substance rather than confirmation. The courtroom was quiet. The vent above the respondent's table continued its low, continuous hum. Somewhere behind me, the court recorder turned a page. At 10:08 a.m., Judge Stanton set the last of Gordon's documents down and opened the supplemental evidence folder that Claire had submitted 6 days earlier. He found document 29 at the indexed position where it had been filed. He read it. He read it a second time. Then he removed his glasses, cleaned them with the cloth he kept folded beside his notepad, replaced them, and looked up at the room with the expression of a man who has located the load-bearing element of a structure that someone else built without accounting for it. "Mr. Ashby," he said. Gordon looked up from his portfolio. "I have before me a supplemental filing submitted by Respondent's Counsel. It includes a certified copy of an irrevocable trust document registered in November of 1998, designating Daniel Mercer as the sole primary beneficiary of the Mercer property." The judge's voice was level, informational, without editorial weight. The irrevocability clause states that this designation cannot be amended, transferred, or superseded by subsequent filing without express written dissolution by the establishing party. He paused. The establishing party was Thomas Mercer, deceased February 2013. The room did not react with noise. Rooms like Courtroom 7 do not produce dramatic sound in response to significant information. What happened instead was a specific quality of stillness, the kind that arrives when several people in the same space simultaneously understand that the architecture of the situation has changed, and not all of them have caught up at the same rate. Gordon's hands were flat on his closed portfolio. He did not speak. "Given the structure of this document," Judge Stanton continued, "I want confirmation from the designated financial institution regarding the current status of the trust and the active beneficiary designation. I have the bank representative present as requested in the supplemental filing." A man in a dark grey suit, sitting along the side wall of the courtroom, whom Rachel had not, until this moment, appeared to register as relevant, stood from the bench and approached the front of the room. He carried a single folder. He identified himself by name and title, confirmed his institution's role as the trust's holding bank, and opened his folder. He read from the trust status record directly. "The irrevocable trust established in November of 1998 remains active and unaltered. The primary beneficiary designation has not been amended. The sole designated primary beneficiary is Daniel Mercer." He closed the folder. No filing subsequent to the trust's establishment carries legal authority to supersede or alter the primary beneficiary designation under the terms of an irrevocable structure. The 2013 nominal title documents referenced in the petitioner's submission do not meet the legal threshold to override this designation. He returned to his seat. Gordon Ashby had not moved. His hands were still flat on the portfolio. His posture, which had been precisely managed throughout the morning, had undergone a change that was not dramatic, but was visible. A slight forward lean, a stillness that was no longer composed but suspended, the posture of a man who has encountered a variable he did not include in his calculations and has not yet determined what to do with it. He looked at the judge. He looked at the bank representative. He looked at the document index on the bench. He did not speak. Rachel pushed her chair back. It was a small motion, 3 or 4 inches, but it was involuntary, and in the context of the particular stillness that had settled over the room, it was audible. She turned toward Gordon with an expression that had crossed from composure into something that required visible effort to manage. Her jaw was set. Her breathing had changed, not labored, but shallower than it had been 20 minutes earlier, the breathing of someone standing in a room that had grown smaller without the walls having moved. "That's wrong," she said. Her voice was low, directed at Gordon rather than at the bench, but the room was quiet enough that it carried. "He has no standing on the 2013 documents. The filing clearly—" "Mrs. Mercer." Judge Stanton's tone did not rise. It did not need to. "Petitioner will address the court through counsel." Rachel stopped. Gordon placed one hand on the table and rose slowly. When he spoke, his voice had lost the rehearsed quality of his earlier presentation. What remained was accurate but reduced, a man choosing words with the caution of someone who has realized mid-step that the floor beneath him is not what he believed it to be. "Your Honor, the petitioner's position is that the 2013 documents establish—" "Mr. Ashby." The judge's voice was patient and final in the same measure. "The 2013 documents establish nominal co-title activity during the marriage. The 1998 trust document establishes an irrevocable primary beneficiary designation that predates the marriage entirely. These are not documents of equivalent authority. The trust's irrevocability clause is unambiguous, and the bank's confirmation of active status removes any question of administrative lapse." He set his pen down. "Is there a legal argument you wish to present as to why the 2013 filings carry superior authority to an irrevocable trust designation?" Gordon Ashby said nothing. He stood at the table with his hand resting on the closed portfolio and said nothing, because there was no argument to make. He had built a case on documents that were real and documented and accurately presented, and none of that changed the fact that they were legally subordinate to a single page his office had received 6 days ago and had not traced to its origin. I looked at the clock above the bench. 10:23 a.m. I did not look at Rachel. I did not need to. I could hear the specific quality of silence from her side of the room, not the composed silence of someone waiting for their attorney to correct a procedural misunderstanding, but the silence of someone who has run a calculation many times and has just in this room at this hour received the first result that does not match. Claire wrote 2 words on the notepad in front of her and angled it slightly toward me without comment. I did not need to read them. I already knew. I left the courthouse alone. Claire had offered to walk out together, to go over next steps, to debrief the way attorneys and clients debrief after a hearing that resolves in their favor. I told her I would call her in the morning. She understood, the way she had understood most things throughout the 14 months we had worked together, without requiring explanation. The air outside was cold and direct. March in this city does not soften. I stopped at the top of the courthouse steps and stood there for a moment, hands in my coat pockets, looking at the street below without any particular destination in mind. I thought about my father. I thought about a man who, in the fall of 1998, had sat across from his estate attorney in an office 1 state over and arranged a single document, quietly, correctly, without telling anyone, without expecting recognition for it. He had not done it to win anything. He had done it because he understood that the structures you build with care outlast the conversations people have about them. He had done it because he believed that clean paperwork, properly filed, was a form of protection that did not expire. He had been right. He had been right for 26 years through a marriage and a death and a divorce proceeding, and he had never known any of it. The document had simply waited in a notary office in a neighboring state, irrevocable, unchanged, patient in the way that things without emotion are patient, not because they endure, but because nothing acts on them. I looked at the street for a while longer. Then I walked down the steps and did not look back. Silence is not the same as surrender. Calm is not the same as weakness. And being underestimated is only dangerous if you begin, over time, to believe the assessment. My father left me a mansion. But what he actually left me was a document, one page registered in 1998, that said everything that needed to be said without ever raising its voice. I have never forgotten that. If you have ever been dismissed, overlooked, or quietly written off by someone who assumed you weren't paying attention, I would like to hear from you. Leave a comment below and tell me where you are watching from.